Episode for high GC News. Meba Obibia Akwaba. Ahadia latest and hot news in Kwa Enamede Bramo. Anuti so when you subscribe to channel area, Bomodia say obe subscribe. Diobian say obe click the subscribe button. Now our belly notification. We had a video for be upload. When the first person that wants a becan AS video. Ave we are now like video give us a thumbs up. Nafi share my wo for so now when you be here now who and someone also Ghana memo. Afi you share yeah and someone better yapno so and idea NDC for one at then a year Supreme Court a year NDC one of the court a year Supreme Court English a year Recollation redeclaring some by a year EC yeah say MPP for Ebenya seat no say Supreme Court aboning in our tuagu. Na yen share a year story about abonting efa a year something when yen for details in mamo yen share story no. Or say Supreme Court quashes High Court ruling ordering AC to recollate 4 seats won by the NDC. Na just say yeah Supreme Court no on my board to go just say reject it you say you invalid a year sir recollation a course so Emma a year 4 seats a year 4 constituency and no Supreme Court aboning in our to go. Afi yen share a year details of the story no say the Supreme Court of Ghana has quashed the ruling of the High Court, which ordered the Electoral Commission of Ghana to recollate and redeclare 4 parliamentary seats initially declared in favor of the NDC. A year 4 seats are declare to say NDC 4 a winning seat. And no actually want to call a recollation and redeclare as it could be a year MPP for and no MDC 4 at the court a year Supreme Court. Say Supreme Court aboning in to a say a invalid just say wa question about to a invalid and ye ne kwanso no. Now also say this is after the Supreme Court of Ghana had an application by the National Democratic Congress NDC challenging the recent declaration and redeclaration of the parliamentary election results of 9 constituencies that were in dispute. 9 constituencies are a year one at home so near and no yes NDC for no at the conda a year Supreme Court in for recollation and redeclaring Sammy. Or say the NDC wanted the court to quash a ruling of the High Court which ordered the Electoral Commission of Ghana EC to recollate and redeclare the results of the 5 constituencies, namely Okaikwei Central, Ablekuma North, Tema Central, Techiman South and Obuasi East. ASR constituency or na year recollation redeclaration a course so then you order a free High Court mark when say EC betimi a year recollation redeclare and no NDC for no annual swatch say one dream contentem a call year Supreme Court tier 7 and a yabo nina to go nature says I sitting in an asaba bedi NDC for no and such as a resetting back. Now what also say they argued that the High Court judge who sat on the case refused to listen to their parliamentary candidate whom the ruling affected, which according to them violate the fundamental rule of law that a court cannot make a final decision which will adversely affect a person who the court did not allow to present his or her side of the story. Now just say answer na court today the judgment and now didn't really be able to about just say afternoon with tea on the side. Meanwhile so NDC 4 one a parliamentary candidate no and yeah there a High Court no a tea on the side of the story and now they sanse win ebe tuja. Now also say the 5-member Supreme Court panel chaired by Justice Gabriel Palman overruled the order of the recollation of the constituencies that were ruled in favor of the NDC, Okaikwei Central, Ablekuma North, Tema Central, Techiman South. Now to also say the court ordered that the High Court, presided by a different judge, should hear the matter again and allow the affected MP elect to defend themselves on Tuesday, January 31st. Not just say a year January 31st, no, and one day a seminar besako. Not just say a year Supreme Court a born seminar to go, no. Just a High Court and be say tia seminar mu yebema judge for fratana assembly so. Now just say a year MP select no one akoka one sem ewo ho a year January 31st. Now answer na no yen share a year yinti a year sa report here fa a year Supreme Court the abeto abontia just say yabo and sem na atu agu no yinti a year sa report by TV3 yinti and sama one day etuja yinti o.
The Supreme Court has quashed the decision of the High Court, which ordered the recollation and declaration of results of Okaikwei Central, Ablekuma North, Techiman South, and Tema Central. The court, in a unanimous 5-0 ruling, also ordered the High Court to rehear the application of the National Democratic Congress on the disputed results of the 4 constituencies. My colleague Lord Asare sat through proceedings.
The Accra High Court last week ordered the Electoral Commission to collate and declare results of parliamentary elections in 6 constituencies, including in Mahamadu Bawumia and Akufo Addo North, after dismissing a restraining order by the NDC. The NDC was not named a party in the MPP's application, filed a joinder to the writ but was declined, and the High Court subsequently gave the EC and the IGP orders, which have since been carried out. In its ruling on Friday, the 5-member panel of justices chastised presiding judge Reverend Joseph Edu Owusu-Agyemang for not giving the NDC hearing to their joinder suit. The Apex Court therefore ordered that the NDC's application be reheard at the High Court on Tuesday, December 31, this time though by a different judge.
We hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwei Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court.
The court also ordered that in Mahamadu Bawumia and Akufo Addo North constituencies results be upheld, since that was not before it. NDC Director of Legal, Godwin Edujitamaklo, expressed satisfaction at the decision of the Apex Court.
At least fairness has been done today, and that is all that we were calling for. The fact that we have to go to the High Court, what strategies we are going to deploy, I will not disclose it. But I just want to thank everyone for this. And I'll urge our party supporters in Ahafano and Suhun to stay calm and watch what we'll be doing going forward.
Gary Nemakon, leading the NPP parliamentary candidates, expressed preparedness for the next hurdle.
They were not heard on the application. They came to court to say that they were not heard. The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response, okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation and a declaration. That is the point. So it's not about recollation. So this word recollation, there is no collation at all.
Was there was also another application for stay of execution, which was at this point had become irrelevant or moot, and so the director of legal of the NDC, Godwin Edujitamaklo, withdrew that application, and that was the second application that you had the court considering. We'll see how the coming days will look like, since there's still a little more to be done on this matter. Lord Asare, TV3 News, Supreme Court.
Right, so that's what transpired in the Supreme Court today. Let me just run you through some of the reliefs that were sought by the NDC legal team that was led by Edujitamaklo today. So on your screens are the reliefs sought by the NDC legal team. An order of certiorari directed at the High Court to quash orders of the High Court dated December 20. Also, they wanted an order of prohibition restraining the parties from collating, recounting and declaring contentious election results and providing security for such actions. And then also an interlocutory injunction restraining the collation, recounting and declaration, as well as declaration of contentious election results pending the suit. And as soon after proceedings, some parliamentary candidates whose seats were being contested spoke to our news team. Take a listen.
We're happy that our confidence in the law has, borne its fruits, and we're happy to go and continue. I think it's important that everybody understands that this is just the beginning of our work. And I think that this experience equips us to be able to represent all our people a lot better.
I think it's a good day for country. The whole world is watching, not just Ghana. So I think it's just the beginning of coming together as one people, And then I think it redeems the image to an extent of our courts and our judges. So it's all well and good.
You're waiting for wedding and some more about a Supreme Court and our boy High Court ruling the man is who can say 1 year Recollation a year for Caesar and this for winning and no High Supreme Court no abo atuegu. Na yentwa and some so a year Deputy EC Chair a year Dr. Bossman Asare okupie wo ye TV3 hwa na yetoto na no FIA Recollation redeclare no na wode ensem bi atudwa na mepese yekohwe sa video yi abra yetoto na no bisibisa ensem FIA Recollation ne sa redeclare hu sensem yi yenkohwe video TV3 for the atudwa yenkoti ensem a ekoso intie
Bossman Asare, who is the deputy chair at the Electoral Commission. I spoke with him just some minutes ago before we came on air. Listen to him and watch him explain why the Electoral Commission did what it did on Saturday.
We are still left with 2 to go. We are very hopeful that we'll get it done way before the swearing in Parliament.
Doc, are you able to tell us which part of the CI 127, the constitutional instrument you used for this year's general election, it was the same you used in 2020, where in that CI that permits the Electoral Commission to recollate results and redeclare winners of parliamentary elections after they've already been declared in the constituencies?
The Constitution, Article 45, says that of all the institutions in Ghana, it's only the Electoral Commission of Ghana which is mandated to conduct and supervise. And when you are supervising the process, if the process doesn't go well, you raise issues and you address the processes. Apart from that, we have CI 127. CI 127 Regulation 43. It provides that when you are doing collation, each candidate is supposed to have 2 agents at the collation center. So anytime there are encroachers at the collation center, it undermines what the law says. Apart from Regulation 43, Regulation 48 also talks about even when agents are not present, the collation can still take place. And the 43 I mentioned, it provides some steps to be followed when you are doing the collation. So once those steps are not followed, and you have an instance whereby somebody is compelled against his or her will or under duress to declare somebody a winner, that is not acceptable as far as the commission is concerned.
So that is the word of the Electoral Commission saying that your officers there were under duress?
No, it's not the word of the Electoral Commission. It's the word of our officers.
Your officers claimed that they were under duress?
You said they claimed.
Yes,
no,
that's what
they
you're
said
saying.
They were under duress.
Let's take it step by step, Doc. You still haven't answered the question of which part of the CI allows the Electoral Commission to recollate results of constituencies and to redeclare.
I think I mentioned, let me come back. I said CI 127, Regulation 43. It provides the framework for collation. So any collation that does not follow that process is unacceptable.
And I will read that very briefly. It says that the returning officer ensures figures from polling stations are corrected and tallied. But then it goes on to say...
The returning officer ensures what?
The returning officer ensures the figures from all polling stations are correctly tallied. Once verified and accepted, a returning officer completes the constituency collation form and declares result. Now, you declare the total number, valid, rejected, and all of that, after which... And there's a part of it where it says that when there is a problem or there's a contestation, the EC may recount at that instant. But it didn't say that after there has been, for instance, after you've passed that stage and you have declared the winner.
What you just read, you said the returning officer must put together all the polling station results.
But I'm arriving at a result. I'm just saying that after you have declared the winner, I didn't see anything in the CI that said that after declaration is done, you go back and say that because there were these previous challenges, we are going to redeclare winner.
No, Billy, let me say this. We have officers, returning officers for each constituency. The same people who declared the results you are claiming they declared said no, that's not what transpired. And that at a gunpoint, at a knife point, I was compelled to declare a winner who didn't win.
Our cameras were there. I don't remember we reported that they put knives and guns on their heads.
Did you watch the declaration of Okaikwei Central? Have you seen the footage?
I did.
Did you hear the officer saying I declared with 78%?
No. But
did you hear that?
I'm asking you a question specific to what you just said, which is the guns and the knives. And I'm saying that I don't recall our cameras recording that.
But usually in those instances,
because that's what you're using to say under duress.
No, the point is under duress, apart from that. But did you see the footage of Okaikwei Central being declared?
Yes.
Did you hear the person saying, I'm declaring with 78% of the polling station?
Yes, we know that in some constituencies they declare.
And we are saying all those are unlawful.
Okay, but what happened in Damango where one person died and where the current lands minister, Abu Jinapo, they declared without all the results?
Are you sure? Damango, they declared with all the results?
No, not with all the polling stations. Also, in the issue of Techiman South, 2020, during the parliamentary election, when the NDC had issues with the result, you told them to go to court. So people are feeling that there's a double standard being played here by the Electoral Commission in this year's general election.
Let me put things in the right context. Techiman South in 2020, the report from our district officer, as well as the return officers, was they had gone through the entire process required by CI 127. They went through the entire process. So when that report came to us, we said, once you've gone through the entire processes, anyone who has an issue with it must use the legal system, because the entire processes they've gone through without any problem. In 2024, they didn't go through the entire process. The same people who did the exercise, those alleged declarations, the same people who did it, those same people came to the commission and said, no, that's not what transpired.
So you don't see what happened in Techiman South and what is happening now as a double standard?
No, it's not anyone who claims what happened in 2020 in Techiman South, what happened in 2024 in Techiman South?
I'm talking about 2020.
No, what happened in 2020?
Where you told the agreed to go to court.
And what has happened? Are you referring to 2024 in Techiman South?
2024, you are not asking the agreed to go to court.
No, because
after the elections have been declared.
2020, the processes were followed. No, they didn't declare. What that was fraudulent declaration, and the commission will not gazette anyone who, in our estimation, went through a fraudulent process.
You are just referring to your men who, and of course that's a fact that is out there, that there were certain constituencies that didn't have all the polling station figures.
And I think you mentioned that one.
Yes, those were your men. So you should be taking responsibility for your men being at a place they've been trained to do this. They know the CI, and yet they went ahead to declare.
So the ones they did at Okaikwei Central, Ablekumanov, Tema Central, they didn't make that point because it would have changed the outcome. I think, Beatrice, one of the things we must understand is that the Electoral Commission is a creation of the Constitution. There are clearly specified functions of the Electoral Commission, and we must perform those functions to the best of our ability, to the letter.
And you think you've done that?
Oh, no, that's what we have done, and we are left with two to go. So the point is that whether someone is happy or someone is unhappy, that shouldn't be an issue. That's why the law provides that if you are not satisfied with what the EC is doing, there is a way to go.
What we also understand is that just after the High Court did that, the NDC filed a certiorari at the Supreme Court to quash the decision of the High Court. What we are being told by NDC executives is that the certiorari was served on the Electoral Commission. You received or acknowledged receipt of that. The police administration,
on Friday.
That's what we are told. The police administration as well. Yet, irrespective of this Supreme Court certiorari, you still went ahead and did what you did on Saturday.
No,
how do you respond?
I don't know about this certiorari at the Supreme Court. I don't know anything about it. But what I want to say is that the Commission has been given clearly defined functions. And those clearly defined functions, what my understanding of the legal process is that if even you are going to take the issue to court over parliamentary or presidential election, what you do is that you must allow the process to come to an end. The processes have not come to an end. So, per the advice from our lawyers, what we did on Saturday was very, very much lawful as far as our laws are.
The lawyers, did it include the Attorney General?
The Attorney General is not our lawyer. We have our own
because internal... the NDC is alleging.
Oh, no, I think that one is new to me.
The Attorney General, when you were contacted as to why you decided to go ahead, despite the certiorari, you said that the AG had advised you
you were referring to was even on Friday. So at what point would we contact the Attorney General? We have never contacted them. We don't do that. We have our own lawyers. We have our in-house and external councils we engage.
Doc, you don't think that what the Electoral Commission has done in this year's general election is setting a bad precedent where perhaps in the future, assuming that the presidential candidate is declared winner, EC can then come back and say that we are sorry, there were ABCD reasons and therefore we are going back?
You know, Beatrice, that cannot happen because the presidential election is declared by the chairperson of the Electoral Commission. Didn't you hear before the elections that all the parties were claiming that by 12 midnight, they would have gotten all the results from the polling station? So what we are doing now, these are results all the parties have. Commission doesn't know the winner of any of these outstanding ones. So what we are saying is that you have your pin sheet, bring all, let's put them together and get the winner. And I'm surprised that some people will have issue with it when we need to ensure that truth is.
And what you just watched there, Dr. Bossman Asare, he's deputy chair of the Electoral Commission. I'll be getting the thoughts of Dafiamekpo very shortly.
My dear, what are we talking about? We are talking about the organization of a public election, i.e., the 2024 December 7th general elections, the presidential and the parliamentary. And let me point out something very poignant. For the first time, the EC directed that presidential ballots will be collated first. You realize that. Often it is parliamentary that is collated first. Then they take their time to collate presidential. So part of the problem that we have had was as a result of this switch. Now, second, the EC is mandated in law to abide the terms and tenor of the regulations governing public elections, especially CI 127/2020, promulgated on 2nd July 2020 by Mensa itself, and the PNDC Law 284, they regulate our public elections. There's nowhere that it says that when you disagree with declarations of parliamentary results, there should be recollation. There's nowhere. Number two, if you check section 20, I believe so, of PNDC law 284, it tells you what an aggrieved party should do, should proceed to court, and how it should proceed in the event that you are aggrieved with the outcome of a public election. The forum convenience for you is to proceed to the High Court. Now, we should pay attention to what has happened. And let me, for instance, speak about the matters that have engaged the public attention from Okaikwei Central, Ablekuma North, Domiko Abinya, Tema Central, and the rest. In Tema Central, at the close of poll on Saturday, polling station results have been collated. A candidate was leading. But by the time they moved to the collation center at Chemu, our lead had been whittled down magically from about 2,300 votes to about 500 votes. Now, the Metro Director for Elections, Mr. Ofosuhini, refused to perform his functions of office. An EC officer who will simply be lethargic in collating results. You see, in collation simply means tabulate, because the calculations have already been done at the polling stations pursuant to Regulation 18 of CI 127. Polling stations have been established and gazetted. So results have been declared. And when results are declared at polling stations, pursuant to Regulation 39, sub-Regulation 3 thereabout, you are supposed to paste copies of the declared results at polling stations. So when the Supreme Court said some time ago that results, the election is won at the polling stations, this is what we used to transpose into our regulation to guide us. There were a lot of presiding officers from these polling stations who were not doing that. So that, in itself, is a material breach. So, in the course of the collation in Tema Central, for instance, on Saturday, somebody decided to create problems from the MPP side. So the police had cause to throw in tear gas. dispersing the marauding crowd. Collation had to be halted. Then announcement was made that we needed to go back or to return the next day to continue with collation. Where were we supposed to do it? We were supposed to do it at the premises of the Tema Regional Police Command. So we were all supposed to have been convened on Tuesday. Then Sunday night, message came that EC in Accra had directed that the collation slated for Tuesday should rather be done on 9th December, Monday. No problem. We went there. We were given the parking lot of the regional commander and his seniors.
I want you to be wrapping up
yes,
on your preliminary.
I'll wrap up on that. Now, when we got there, the returning officer, who is mandated in law under Regulation 2 and Regulation 3 of CI 127 to commandeer the collation process, Mr. Kwesi Brobe, has been silent. And one Mr. Fosuhini, who is the Metro Director of Elections for Tema Central, now decided to take charge. He decided to conduct the collation according to his whims, according to his desires, according to his thinking, and appointed it out to him, but no. We are enjoined in law to do the collation in accordance with law. The power that you have to reject a bad ballot, for instance, when somebody tamprints and it doesn't land in the rectangular box provided against the name of a contestant, that you, the elections officer or electoral officer, can have the power to reject it or to declare it as a rejected ballot. In the same way, where pink sheets have been fabricated clearly, they ought to be rejected. And very briefly, you won't have any of that. Very briefly, before I go on, we do have the Electoral Commission responding to some of these issues, including the certiorari. The NDC says you filed at the Supreme Court after the High Court rejected your injunction application against the mandamos that was filed by the NPP. But you heard Andy Apia could be there. Yes, so you heard when we come back, you heard Andy Apia could be saying that the fact that, you know, I quoted to him the expressio rule, and he counted it. He counted it and talked about the fact that the law says this doesn't mean that if people feel that they've made a mistake, they shouldn't go back to correct that. Can I get your brief comment, and then we'll hear from the Electoral Commission really telling us why they thought they had to do what they did on Saturday. Now, where somebody alleges a mistake in terms of declaration, citing reasons like under duress, citing reasons like threat and all that, those are not matters that the EC has the power to pronounce on. When you say that I have threatened you or I place you under duress, you are making an allegation. So you must go to court, swear to an oath, you enter the witness box. I need to cross-examine you because you are going to lead evidence of the duress. You are going to particularize the incidents of the duress. And I should be able to cross-examine you on these allegations. Yes, first of all, my senior Andy, my senior at the bar, and my senior in practice, and he got his analysis wrong. In philosophy, in reasoning, in logic, I cannot simply say his position, I disagree with his position in law without establishing the major articulate premise. In logic, there's what we call major articulate premise and minor articulate premise. I must establish that your law is wrong so that I can disagree with you. I cannot simply say I disagree with you without establishing that the position you are espousing in law is wrong or not. So it is part of our court language to say that my learned friend's position in law is wrong, or the position he is espousing before the court is wrong. That is court language. I disagree with him because he's wrong. Then I can espouse the position that I think is correct in terms of the law before the judge. So you shouldn't take issues with that. Now, in all this, you discover that on the 10th of December, when Afenyo Markins held a press conference and demanded the EC to nullify all so-called unlawfully declared parliamentary outcomes in respect of these constituencies, that was when the EC moved into action. I want to establish a certain pattern. How come the EC, as part of the court processes that they claim that we are gone through yesterday, they are not recollating the results from Fantiakwanov? Fantiakwanov was originally declared for the NDC. The NPP brought it back to Tesano and got it declared for the NPP by an unaccredited EC staff. In rehabilitating these matters, the EC has refused to include Fantiakwanov.
So the point you're making is?
The point I'm making is that the EC, in fact, the EC is rather the most dangerous constitutional body we have. Bossman Asare is talking about fraudulent declarations. And that when some people make allegations of fraudulent declarations, it's up to the EC to determine. It is not. It's up to a court of law. So you see, our trust in the EC has completely been eroded. Because you see, if you have an EC populated by Jaimensa, Dr. Srebo, Dr. Bossman Asare, Dr. Piahini, and Samuel Tete, who are unashamedly NPP aligned, then you have a problem. He sits there and say that they have the power to determine. We know of the Apia man at EC, but you're including Apiahini. Apiahini. We've spoken about him, but you're including. I'm actually in court. I'm actually in court regarding his appointment, and the matter has been in court for about 2 years now. I'm aware of that one. Yes. So I am saying. But I'm just wondering why you're including Samuel Tete and Bossman Asare. Why Samuel Tete? They're all senior officers. It was Samuel Tete who had a press conference and said that they were not going to respect the declarations made their officers at their respective collation centers in these respective constituencies. Meanwhile, the law in Regulation 3 of CI 127, it is the returning officers who have the power to make these declarations. And if you could be wrapping up for us, yes, let me wrap up. I am saying that, look, Bossman Asare today says that if we are not satisfied with what the EC has done, we should go to court. What has the EC done? The declarations that were made on the 9th of December, on the 8th of December, on the 9th of 7th of December, were they made by GPRTU officers? Those declarations, were they made by GPRTU officers? They were made by EC officials who were mandated in law to do. So if somebody now decided that, look, you guys go and write a petition. If you write a petition to us, we will act on it. That is what they have done. Because the petition only came from Ofusuhini. You heard us, Bossman Asare saying that those same individuals came back to say they were. He alluded to the fact that somebody had a gun pointed to his head. When we asked him, he ran away from that point. And was alluding to the fact that did you see the declarations from Okaikwei Central and that the person said he was declaring pursuant to 70% of the pink sheet. You made a categorical allegation that somebody had gun pointed to his head. This is the choreographed narrative that they have had with the NPP. So this is what the NPP says. His narrative on this matter is no different from what the NPP is saying. Wrap up in like 30 seconds for me, and I'll get the final word. Now I am saying that the EC itself has become a very lawless institution. They have refused to have regard to court processes that the NDC has filed. You say we should go to court. We went to court before you ordered for recollation. When you are in court, the law mandates you to respect court processes. Even if you think the outcome will not favor whoever has gone to court, respect the court processes. And we understand you're citing the EC for contempt. Is that what it is? Of course we'll do that. Okay. And let me tell the EC officers that pursuant to Regulation 45(2) of CI 127, they are subject to penal provisions where we think that their conduct that was supposed to have been that have been carried out in pursuance of CI 127 were not so done. We'll have to end it here. Thank you very much. Thank you very much. Nelson Roxon Dafiame. He's a member of parliament for South Dine and a lawyer as well with the incoming NDC government.
Yo, waiting for winning and someone Alberto Yapono so a year high court ruling na ema isi kwan se one year recollation declare no eno na year Supreme Court abo a year sarudi nyina atuagu na koye ensem bebre meka ho se so when you subscribe to channel dia bomodi ase over subscribe and say hadia latest and hot news enkwa era me de bremo afi we na wa like the video na fi share ma wo foforo so na when you be here na wo hu ensem ekoso e wo Ghana memu also betimi atchere wadwen afa eye ensem we nyina ho e wo comment box ni mu mobeti menka bi in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. click on the bell to turn on the notification.